afternoon and welcome to our webinar. I'm just going to give it a couple minutes for everybody to be able to get into the webinar and then we'll get started. Welcome to our webinar today on standing and attorney's fees and mortgage foreclosure and collection cases. My name is Laura Beckman and I'm the chair of the, the Public Interest Law Section Consumer and Tenant Protection Committee. If you're not already a member of PILS, we strongly urge you to join. It's a great section and very affordable. And this is going to be the last in a series of webinars that our committee has done so far this year. And so we are very thankful to Legal Services of North Florida, who's made it possible for us to be able to offer these webinars for free. And we appreciate you joining us today. If you have any questions throughout the course of the webinar, in your GoToMeeting box, there's a place where you can post questions, and we'll be fielding questions and sharing those with Matt throughout the webinar today. So please feel free to post any questions you might have there. Please join me in welcoming Matthew Baird, who's with us today presenting on our topic. Matt's a staff attorney at the Homeownership and Consumer Unit of Legal Services of Greater Miami, where he's worked for the past 12 years. His practice areas include foreclosure defense, consumer rights litigation, and bankruptcy. He's a longtime member of the Florida Bar's Public Interest Law Section, Consumer and Tenant Protection Committee. And we're very thankful to have him on our committee and very thankful that he has agreed to present today on a couple of very important cases that have developed the field of attorney's fees and consumer protection law. Matt, go ahead and take it away.
Okay, thanks, Laura. So yeah, as Laura said, my name is Matt Baird. I'm an attorney here at Legal Services of Greater Miami. I practice in our homeownership and consumer unit, primarily doing foreclosure defense, debt collection defense, and bankruptcy. So thank you all for joining us. Today's webinar, I'll be discussing two cases that are currently before the Florida Supreme Court. One is a foreclosure case and the other is a debt collection case. And both of these cases involve defendants who were successful in the litigation and successfully they won their cases, but were at some point denied recovery of their attorney's fees. And the decisions that the Supreme Court is going to make on both of these cases are going to have very important impacts for defendants in foreclosure and debt collection cases on whether they're going to be able to continue to recover attorney's fees, and as an upshot of that, whether they're going to be able to retain quality attorneys in foreclosure and debt collection cases. So just to sort of start with some context, when we talk about entitlement to fees in cases, Florida follows what's known as the American rule, which simply states that attorney's fees may only be awarded by a court when authorized by a contract or statute. So in other words, if you're in litigation, you win the case, you're not automatically going to get your attorney's fees. There needs to be some either rule or if it's a contract dispute, some provision in the contract that allows the prevailing party to recover their fees. And the statute that we're going to be focused on today is 57105 subsection 7. 57105 is a pretty comprehensive statute. It has a lot of provisions, but the one we're going to be focused on is the very last paragraph of 57105, which is part 7. And simply put, it states that if a contract between two parties allows one party to recover fees, if there's litigation on that contract and the the party that's not named as has the right to recover fees prevails in the litigation, then that party will also have the right to recover their fees. You can see I put the statute here on the slide. And in the statute, the italicized phrases that at the end there, that party that prevails in any action, whether it's plaintiff or defendant, with respect to a contract, those are my italics, and I wanted to emphasize those particular parts of the statute because they're going to arise again and again, and the court's interpretation of what any action with respect to a contract means is going to be very relevant to how they interpret the statute and whether the prevailing party, the defending party, is able to recover their fees. So the legislative purpose, there's not a whole lot of case law that examines the legislative purpose or the underlying reasoning policy behind 57105. It was a statute that that part of it came, I think, in the 1980s. That part was added in. But one of the cases is a case that's often cited. It's the Porterweld case, and the court in that case said that, or interpreted the statute, or interpreted the legislative purpose behind the statute to be to level the playing field between parties of unequal bargaining power and sophistication. So, in other words, in modern, transactions, usually, for example, like banking transactions or mortgage transactions, one party sort of holds all the cards. If you want to get a mortgage, you sort of have to accept the terms that the bank is offering to you on that mortgage. And of course, since the banks are the ones that have the economic power, they're going to draft the contracts to benefit themselves. If these cases later come to litigation, the courts want to make sure that there's a level playing field between the parties, and that one party that has the economic power doesn't have more power in the court case. So 57105 provides a sort of reciprocation between the two parties, so that the more well-funded party, the more advantaged party, can't just sort of take advantage during litigation because of provisions that they were able to dictate in the contract. Another quote I've put up here comes from an unreported case, but it's important when you're looking at the scope of how 571057 applies. That court found that the legislature could have, in the statute, limited the scope of the provision to just actions for breach of contract. But they didn't do that. If you look at the plain language of the statute, they provided that a fee award could result when a party prevails in any action, again, with respect to that contract. And that sort of with respect is sort of at the heart of the litigation that's going on right now in front of the Supreme Court. And so one of the areas that this has become sort of a hot topic very recently on is in the area of foreclosure defense, and specifically when defendants raise lack of standing as a defense in a residential foreclosure case. So when we talk about standing, there's a lot of case law out there on standing. I'm assuming if anybody who's on the webinar right now has defended a foreclosure case, you've probably raised standing as a defense. It's one of the most common defenses. It's also one of the most effective defenses in mortgage foreclosure cases. But just sort of a brief rundown on the theory behind it. Nowadays when people take out mortgages, the originating lender rarely owns the mortgage for the life of the entire mortgage, whether 30 or 40 years. Usually what happens is that the mortgages are bundled into packages and sold on the secondary market. That's what, they're bundled as asset-backed securities or securitized trusts. They put thousands of them together and then sell them to other mortgage lenders or mortgage banks. They can often be sold more than one time. So often, there's a number of different parties that will actually own a mortgage during the life of the mortgage. And in the general theories now that have been developed by the courts, when a lender brings an action, or when one of these assignees of an original mortgage brings an action, they have to prove, one of the elements they have to prove in their case is that they have standing to enforce that mortgage. And the way that they do that, generally speaking, is that they'll look to, when you take out a mortgage, you'll sign both the mortgage and a promissory note. A promissory note is like an IOU. The mortgage is the document or the instrument that gives the owner a security interest in the homeowner's property. And in order to prove that they have the right to enforce the mortgage, the plaintiffs have to prove that they have ownership and that they hold the promissory note. Promissory notes are negotiable instruments. They can be transferred between parties when they have what's called an endorsement on them. Again, I'm sure if you've litigated any mortgage foreclosure cases, you know what I'm talking about, and you've seen these endorsements. Oftentimes, these endorsements are in blank. In other words, it'll say "pay to blank," and then it'll have be signed by a assistant vice president of the bank that's transferring the mortgage. And so what happens when it's signed in blank is it becomes payable to its bearer. This is really common practice in when these things are sold. So who actually has possession of that promissory note becomes very important, and it's something that the banks need to prove when they do bring a foreclosure action. There's probably hundreds of cases in Florida explaining the sort of requirements for standing and proving that you own the note and the mortgage. If you're a bank, this Jean Jacques case is one of those. There's many others that probably explain it just as well, but I put Jean Jacques here if you want to read more about standing. So the reason that standing has become such a big issue was, you've probably heard about the robo-signing scandals that were happening during the height of the foreclosure crisis, 2008, 2009, 2010. And it had gotten so bad with the banks being able to prove that they were able to enforce these mortgages when lenders, when defendants would raise the issue in at trial, that the Florida legislature actually had to go back and change their rules to sort of cut down on the number of bad standing issues. And the legislature enacted statute 702-1054. So now when a bank brings a foreclosure case, they have to certify at the outset of the case that they have possession of the note, just to sort of cut down on all the litigation that the courts were seeing, and the robo-signing issues. The Florida Rules of Civil Procedure were also amended. So now in a foreclosure case, the banks actually plaintiffs have to verify that the facts that they state in their case that they have possession of the note and mortgage are true. So standing, obviously, it's been reported on often, and it's a big issue. Defendants are often successful in raising an issue, even with all the sort of safeguards that have been put in place over the last few years. If a homeowner wins their case on standing, which often happens, a lot of times that involves a lot of work. The homeowner's attorney probably did some discovery, maybe took some depositions, cross-examined the witness at trial, and if they prevail, they want to recover. She wants to recover her fees. And so what a typical lawyer would do would be to look to the provisions of the mortgage. And I've cited one here. These are all uniform instruments usually, so they're all pretty similar. But a typical mortgage provision might say a lender shall be entitled to collect its reasonable attorney's fees in foreclosing on this. Again, if you refer back to the 57-1057, the reciprocity provisions, if it's good for the lender to recover their fees, then to coin a phrase, what's good for the goose is good for the gander. The homeowner, as a prevailing party, is also able to recover her fees when they prevail in that action. So often, attorneys will, upon prevailing in the case, will move for their fees. So whether a successful defendant who successfully argued standing in this context is going to be able to recover their fees, right now, a lot depends on what circuit the case was brought in, because right now there's a split between the circuits, and it's one of the things that the Supreme Court is probably going to resolve in the case that's now before it. So it'll apply to the entire state. But one of the earlier cases that came out on this issue was this Fitzgerald case out of the 3rd DCA. And in that case, a homeowner won a trial based on because she was able to prove that the bank didn't have evidence of ownership of the note and the mortgage. So the bank didn't have standing to enforce the mortgage against her. The trial court awarded her a substantial amount of fees, $34,000. So it was a lot of work that went into that case, and a lot of fees that were going to be recovered by the defendant. But on appeal, the 3rd DCA reversed and found that in awarding the final judgment to the homeowner, the trial court had determined that no contract existed between the bank, by which they meant the assignee, or the plaintiff in the case, the plaintiff assignee, and the homeowner. And because because the homeowner was able to prove that the bank was, or the assignee was not the proper party, the third DCA found that she was not able to take advantage of the contractual terms of the mortgage, which provided for attorney's fees. So in other words, she couldn't argue that the bank wasn't the proper party and still held that the bank was liable for her attorney's fees under the provisions of the mortgage. And the third DCA, you can see the language there that I italicized, really focused on the sort of contractual relationship between the assignee and the homeowner. And it found that no contract existed between those parties. And therefore she couldn't invoke the compelled mutuality provisions of 57-1057. So, and that remains still the state of the law in the third DCA. Moving over to the fifth DCA, the controlling precedent right in the fifth DCA right now is this case, the HFC Collections versus Alexander case. This is not actually a foreclosure case. It was a credit card collection case, but it has since been cited in a number of foreclosure cases, so it does apply to foreclosure cases. But what happened here, the HFC was a debt buyer. There's in the credit card debt collection arena, it's similar to the mortgage arena, where credit card debts are often sold to different parties. There's companies called debt buyers that specialize in buying defaulted credit card debts and collecting on them, usually by lawsuits. But they weren't the original party that issued the credit card. So again, oftentimes these things can be transferred to a number of different parties. In this case, the party that brought the action, HFC, failed to prove that it was a real party in interest because it couldn't produce the assignments. So the defendant prevailed at the child level and was awarded fees. The fifth DCA actually ended up reversing that award of fees, and they found the homeowner couldn't employ that mutuality provision of 57-1057 because, again, she proved that HFC was not a party, didn't have the right to enforce the credit card agreement. What's notable about this case, the fifth DCA, the debtor, Alexander, brought an argument that, look, during the course of the litigation, HFC, maintained that they had standing to enforce this. After they lost, they then sort of took the position that the credit card contract didn't apply to them, and she raised an estoppel argument that HFC should be stopped from sort of taking two contrary and mutually exclusive positions. The court rejected that argument, ultimately didn't buy it, but it was an argument that was raised by her. It's important to note, though, this HFC case, at the end of the day, the fifth DCA, even though they said you can't recover under 57-1057, you can't recover your attorney's fees under that provision of 57-105, the court went to sort of great lengths in its opinion to sort of lay out, when it remanded the case to the trial court, to sort of lay out a roadmap for the trial court that even though they weren't available under 57-1057, that because HFC had so repeatedly misrepresented its position that it had standing to enforce the loan, that it could be liable for fees under a different provision of 57-105, which is 57-105-1, which is the sanctions provision of 57-105. And 57-105, I think 1 and 57-105-4 allow a court on its own initiative to issue sanctions against a party if that party takes a baseless position. And in this case, the fifth DCA really went to great lengths to sort of explain to the trial court, you can't award fees on this basis, but really, really consider if you can award fees on the, for HFC's, baseless claims of standing. And I think ultimately at the end of when that case resolved, the trial court did exactly that and awarded a substantial amount of fees on its own initiative based on its sanctioning power. Another case I put in here, this Mestre case here at the bottom, that's a case, I put it here because it came out of the fifth DCA. It's not on standing. It's on sort of the inverse of standing, but it does have implications for 57-1057. And in that case, what actually happened was a defendant was sued by a bank to foreclose on a mortgage. Defendant argued that it wasn't her signature on the mortgage, and ultimately the court agreed with her and said, "You're right. You're not liable for this mortgage because you didn't sign it." The defendant in that case, moved for fees, and the court said, "Well, because your signature was forged, the mortgage was void ab initio, meaning void from the beginning, and no contract was ever formed. So because no contract was ever formed, you're not entitled to recover your fees because there was no contract that would allow you to recover these fees." So again, this isn't on standing itself, this Mestry case, but it is an important case for anybody who does debt collection litigation, because a lot of times these ID theft cases are going to come up. Your clients will tell you, that's not my credit card, or that's not my debt. So if you're litigating those kind of cases, it's important to keep this Mestre opinion in mind, because at the end of the day, you have to think, was the contract even formed or not, if you're arguing that the debt's not the defending party's debt. So now we have the third and the fifth DCAs both saying that you can't recover fees in standing cases, or when you prevail on standing issues. The first DCA sort of runs contrary to that. In the first DCA, there was this Williams case. Bank failed to show it owned the note and mortgage. Defendant not only prevailed and was awarded fees, but was actually given a multiplier, which means that she wasn't going to just recover the number of hours. Her attorney wasn't just going to recover the number of hours that were spent in the case. They were actually going to multiply that by 2.5. So it's a pretty substantial recovery. This case is a little bit older. There's not a whole lot of discussion on the standing issue here, but it's cited as a case that where a court ruled in defendant's favor on standing and also awarded fees, which is contrary to the Fitzgerald and the HFC opinions and the other DCAs. So right now in the first DCA, if you practice in the first DCA, you win on standing, you still might be able to recover your fees based on that sort of precedent. Second DCA is a little bit different. There's a number of cases here that are cited. They're mostly standing cases, but they're also not in the opinions themselves, but later on the court went ahead and awarded fees when the defendant prevailed on standing, but they're not actually discussed in the opinions. So the second DCA is sort of in the maybe column right now on whether you can recover fees or not. There is an unreported decision that was cited by one of the parties in the case that's now before the Supreme Court, where they attached a unreported opinion that shows the second DCA you can't recover fees. So second DCA I think could go both ways. There's not any that I know about. There's not any binding precedents there, but there are a lot of cases that do award fees, and apparently there's some cases that don't award fees. So first and second, first you may be able to recover, second may be able to recover, third and fifth you're probably not going to be able to recover if you prevail on standing. So that brings us to the fourth DCA and the case that's now currently before the Supreme Court, which is the case of NationStar versus Glass. That's the opinion here. Glass, the sort of procedural history of Glass is important, and what happened at the trial court to what's relevant now at the Supreme Court. And what happened in Glass is a homeowner was facing foreclosure, I think, of a reverse mortgage. She filed a motion to dismiss, which raised four legally distinct arguments, of which standing was one of those arguments. I think the other ones were lack of condition precedent, failure to state a cause of action. But there were, standing was only one of four arguments in that case. So what happened was the trial court dismissed the case without making any findings about why they dismissed the case. I think they just granted the motion to dismiss the foreclosure, and NationStar appealed the dismissal itself, not an award of fees. They appealed the dismissal of the case. NationStar later voluntarily dismissed its appeal, and at that point, Glass moved for fees from the fourth DCA. And what happened was that fourth DCA denied Glass's entitlement to fees. They found that Glass had prevailed at the trial court on lack of standing grounds. Now, at the Supreme Court level, her attorneys dispute that was what the trial court found. The fourth DCA reason that, again, similar to Fitzgerald in the Alexander case, Glass had asserted that the foreclosing plaintiff didn't have the right to bring the contract, and because she was able to prove that they didn't have the right to bring the foreclosure under the contract, and because she was able to prove that they didn't have the right to bring the foreclosure as an assignee, she couldn't take advantage of a provision of that same contract. So Glass then invoked the conflict jurisdiction of the Florida Supreme Court, which has been accepted by the Florida Supreme Court, and that bottom citation there is the opinion from the Florida Supreme Court accepting jurisdiction over the case. And the case is still pending before the Supreme Court. I think it's been pending since March, so decision could come down at any time. But the arguments that the parties made to the Supreme Court, there's a number of different arguments that Glass thinks she's going to be able to recover her fees on. And the first two arguments, which are on this slide, are sort of procedural arguments. They don't really get to the heart of the statute itself, the 57-1057 itself. But the procedural arguments, one of the first argument that she raised was, look, we brought a motion to dismiss. The court could have dismissed it on any of the four grounds that we raised. And the trial court just dismissed the case without identifying standing as an issue, didn't specifically rule on standing. So then when NationStar voluntarily dismissed its appeal, Glass says that she's entitled to fees pursuant to another Supreme Court case, this Thornburg versus City of Walton Beach case. And in that case, that's an important case because a lot of these cases do end up as voluntary dismissals, through the litigation when the plaintiffs realize that the evidence probably isn't there, or it's not worth the cost of pursuing at that point. Maybe they want to file a new case, though a lot of times they will take these voluntary dismissals. So what this Thornburg case holds is that when a party voluntarily dismisses a case during the course of the litigation, the other party is considered to be, in general terms, the other party is considered to be the prevailing party, and can be awarded fees under the prevailing party, under the idea that they're the prevailing party. Again, Glass says, well, these other three grounds that could have given rise to the dismissal, wouldn't necessarily show that the plaintiff wasn't a party to the contract. So she says that the fourth DCA improperly sort of rewrote the trial court's ruling to make it appear that the grounds for the dismissal were standing when they might not have actually been standing. So that's one of the arguments that she raised. She actually argues it pretty well, I think, if you read her brief. But the Supreme Court may actually rule that that's correct and sort of punt on the whole standing issue. The fact that the Supreme Court has taken this up on conflict jurisdiction, I think, probably indicates that they're not going to do that. They're not going to rule on this argument that she's made. But it's possible that she might, that the Supreme Court might. The other procedural argument that she made is this litigation estoppel argument. Again, she cites to a fourth DCA case, MCG Financial Services. Again, if a plaintiff files a suit where they assert standing, they should not be allowed to disavow that same legal status just in order to avoid fees. In other words, they can't sort of have their cake and eat it too. But both sides in this litigation have accused the other side of trying to do that. But that is one of the arguments that she raised. And again, that is one of the arguments that the Supreme Court may take up. And it is sort of rooted in some precedent there. So Supreme Court might find for Glass on those grounds as well. That's sort of the real, the heart of the matter, the real sort of meat and potatoes on why this is going to be an impactful case is the interpretation that the Supreme Court is going to give of 57-1057. And so the sort of real litigation here, the real arguments are centered around how the Supreme Court should interpret 571057. And the arguments raised by Glass and some of the amicus briefs that were filed on behalf of Glass. And full disclosure, which I probably should have given at the beginning, is I participated in, or I helped write one of the amicus briefs that was in support of Glass. So I do have a dog in this fight, so I may come off as a little bit biased here. I'll try to be as objective as possible, but I was one of the amicus brief, or participants in the amicus brief in this case, in support of Glass. So again, Glass says you need to focus on the plain language of the statute, which says any action, foreclosure is an action with respect to the contract. Foreclosure is an action, and it is with respect to the contract. She argues that, and this is fleshed out more in the amicus briefs, but also by Glass herself. She argues that the fourth DCA incorrectly interpreted the word party to mean party to the contract. So when you go back and you look, I'm going to bring it up again, at 57105, when it uses this term party, what the legislator really meant was not party to the contract, but a party to the lawsuit or a party to the litigation. So when the Supreme Court interprets 57105, they shouldn't interpret party to mean it has to be a contracting party. Party should be read as the plaintiff in the case is a party to the case by virtue of the fact that they brought the case. And she cites to the rest of 57105, which again is a pretty broad statute, and every time party is used in that statute, the whole which needs to be read holistically, it refers to a party to the litigation or a party to the case, not a party to the contract. So she argues that under that reading, party should have a more expansive reading, and it should apply to any party who is involved in the litigation, not just a party to the contract. She also argues, or this is again fleshed out more in some of the amicus briefs, but another argument that's been raised is that the fourth DCA confuses two sort of different standards here. And one is, if a party brings an action and they're later determined to be that they don't have the right to enforce that contract, that's a different finding than saying that no contract exists. And in this case, or in the Glass case, nobody's disputing that a contract exists. Both parties agree that a contract exists. But the fact is, what the courts really found was that the plaintiff in the case didn't have the right to enforce the contract, but the contract is still a legally binding agreement. And just because they weren't able to prove that they had the right to enforce it doesn't mean that it didn't come into existence, and therefore that the provisions, particularly the attorney's fees provision, doesn't apply. It's sort of a same argument as the party to the contract, party to the litigation argument, but just sort of stated a different way, I think. But those are the arguments that she made that focused on sort of the plain language of 57105 itself. I also raised a number of policy arguments behind 57105. Again, the amicus briefs flesh these out as well. I put this quote here. It's not actually from a Florida case, this quote at the top of this slide, but I think it really sums up sort of the reasoning behind the policy behind these reciprocal fee statutes. Other states, I think about 10 other states have these sort of reciprocal fee statutes. They're all worded similarly, and one of the states is Connecticut. And a Connecticut court, when it was analyzing its own statute, said, the purpose of this reciprocal fee statute will not only discourage frivolous lawsuits, but it will place the burden where it belongs on which really I think that should be, it's talking about the burden of the cost of litigation. The burden where it belongs on the party with a poorly thought out complaint or hastily conceived writ. So in other words, the sort of policy behind this, behind the application of 57105 is it fair that a homeowner should bear the cost of litigation when the bank, who is the more economically advantaged party, raised these bogus allegations and forced the homeowner in a position where they had to defend the case, which ended up having no merit? Isn't the purpose behind 57105 to sort of prevent this sort of unequal application of the law, where if the bank had won the case, they would be able to recover their fees. But because they, even though they brought a meritless case, now the defendant is stuck with the cost of the litigation, which is precisely the sort of situation that 57105(7) was designed to prevent. The other policy implications here is that, if defendants aren't allowed to recover their fees, there's going to be a chilling effect on whether defendants are going to be able to retain attorneys when they're faced with these cases, even if, they're meritless cases. Are defendants going to be able to get attorneys to represent them if the attorneys, especially if they're low income and they can't afford to pay, the attorneys? Will attorneys represent them on a contingency fee basis, even in meritorious cases? And if not, if the attorneys aren't able to recover their fees, that's going to result in a lot of, especially low-income Floridians, not being able to retain attorneys to defend their cases. And there's a number of studies and a number of statistics that show, if in order to have really meaningful access to justice in some of these more complex cases, whether you have an attorney or not, it's going to make a huge difference. Pro se parties rarely win foreclosures or debt collection cases. So in order to have like a meaningful access to the courts, there needs to be a mechanism for low-income people to retain attorneys. And without this reciprocal fee provision being enforced or being applied in these cases, that may not happen, and it's going to result in lack of access to the courts for a lot of defendants.
Matt,
and again,
can I jump in with a couple of questions?
Sure.
Yeah, we've gotten a couple questions so far. One of them is, isn't the chilling effect the real objective of the majority's decision in Glass?
Well, I don't know. Obviously, I don't think the fourth DCA is going to say, we want less people to have access to attorneys. So I don't know if that's true or not. If I'm understanding the question correctly, I don't think there's anything in the Glass opinion that I can remember where they specifically say that they want to have that they don't want to provide too many attorneys fees to defendants, so that they in those cases. So I guess the answer is I don't know. I don't know if there's anything in the Glass opinion itself, if I'm understanding the question correctly.
Yeah, they probably don't come right out and say it, but I think a lot of
I mean it's possible. I would think something like that. Well, okay, I'll may come out of another DCA that's more noted for being pro bank. I won't say which DCA, but yeah, I guess it's possible. But I don't think they're going to come out and admit that.
And then other states have these existing statutes that clarify that it applies to the parties whether or not they're a party to the contract. Do you think that that'll be relevant to the court's decision, the way other states interpret the statute?
Right. Well, that was, some of the things that were brought up in the amicus briefs on behalf of Glass was citing to these other states' statutes. I think California, Utah, Oregon, Connecticut, four that I remember off the top of my head. And I think that's correct that, these states usually rule in favor of the defending party, or the party that's not provided for attorney's fees in the contract. I think it would be advantageous for Glass if the Supreme Court considers other states and how they interpret the laws. I don't know whether the Supreme Court is going to do that or not, but I definitely think if they do that, then it'll bode in favor of Glass recovering her fees.
Gotcha. And then one more for right now. Do you think the fact that 3 of our justices are retiring in January means that we will likely have a decision on Glass before they retire?
I'm sorry, Laura, you kind of cut out there.
Oh, sorry. Do you think the fact that 3 of the justices are retiring in January means that we'll likely have a decision on glass before they retire?
Oh boy. Hello, can you guys hear me?
Yeah. Can you hear us?
Laura, you kind of cut out on that last question.
I'm
I'm not
sorry.
sure what
Can you
happened.
hear me?
Yeah, I can hear you now. Okay.
Oh, I'm sorry. Do you think the fact that 3 of the justices are retiring in January means that we will likely have a decision on glass before they retire?
That I don't even want to speculate to. I'm not an expert on sort of Supreme Court jurisprudence. I'm sure there's probably people that would be way more well qualified, who's sort of Supreme Court watchers who would know that. Yeah, I mean, common sense, I would think, but yes, it probably would. They probably would want to, rule on it before the court changes.
Okay, thanks.
True in
Those are all the
in
questions
any case
I
right
have
now
for
that's
right
before
now.
the Supreme Court.
Thanks.
Okay, all right. So let me move on. So those are the sort of policy arguments behind Glass and her amicus briefs. Nation Star's response. I'm just going to summarize this real quick. 57105, because it sort of contravenes the baseline rule, or the sort of default rule, which is the American rule, which is that sort of an anti-recovery of attorney's fees rule, or the rule sort of makes it harder to get attorney's fees. Because 57105 is a derogation of that baseline rule, it should be narrowly construed. Glass is arguing for a more broad construal of the rule, but the courts, according to Nation Star, should give it a more narrow application to sort of just what it says. And this maybe would touch on one of the questions that was asked before. Nation Star also cites to the legislative history of 57105.7. They say that in the legislative history, when the legislature was sort of considering the statute, they referred to parties to a contract as opposed to parties to litigation that Glass is arguing for. And so the legislative history supports the fourth DCA's reading of this. They also argue that Glass bears, as the moving party, Glass bears the burden of establishing the right to fees. So it's her burden to prove that this contract exists between the parties. It doesn't just automatically, it's not just automatically assumed, and that Glass had failed to prove that, at the lower courts. So, and that's sort of where the case sits right now. The case has been fully briefed, and amicus briefs have been filed, and right now I think we're just waiting for the Supreme Court to make a decision. I don't think there's going to be oral arguments, so it's just going to be done on the pleadings, and yeah, so we're just waiting. Could come out any time now. So definitely something to keep an eye on, over the next few weeks, months, maybe before they retire. I guess I don't really know how to predict the Supreme Court, but it's definitely something to keep an eye on. And I'm sure there'll be a lot of information when the Supreme Court does actually rule on this. So I wanted to switch gears now. If the Supreme Court does rule against Glass, attorneys who do this sort of work are going to need to find other ways. If they're going to want to still keep doing this work and keep recovering their fees, they're going to need to find other ways to recover their fees besides 57105.7. So I wanted to sort of give a quick review of some of the legal theories by which, assuming the worst case scenario for Glass and the Supreme Court rules against her and says 57105.7 doesn't apply when you prevail on standing, some other ways attorneys might be able to get fees in these cases. A lot of these theories were sort of thrown out by the lower courts when they denied under 57105.7. So I'm just going to highlight those that were brought by other courts. First off, there's a relatively recent case called Mattel versus Wells Fargo, which is a Fifth Circuit case, came out, I think, May 2018. So Fifth Circuit, same one that issued the HFC versus Alexander case, they also issued this Mattel opinion. And that's a really interesting case. In that case, it's based on this idea that when a plaintiff brings a foreclosure, they have to prove that they had standing from the outset of the case. In other words, when they file the complaint, they have to have all their ducks in a row. And they have to have ownership or hold the promissory note and have standing to enforce the case when they file it. They can't file a case and then later on acquire standing, before trial. They can't just be that they have standing at trial or at summary judgment. They have to have standing throughout the case, starting at the beginning of the case. So in Mattel, what happened, and the court does say that this is a sort of extraordinary set of circumstances, but in Mattel, what happened was the plaintiff brought the case. There was years and years of litigation. During the course of the litigation, it came out that the plaintiff was able to get the original promissory note, and therefore that they had standing. However, they were not able to prove that they had standing from the outset of the case. So the court, the Fifth DCA in Mattel, even though the plaintiffs, the bank, the foreclosing bank, after the case was dismissed because they didn't have standing, they raised the Alexander Glass, they raised all the Fitzgerald cases. The court said, no, those cases don't apply here because under this set of circumstances, the plaintiff is a party to the contract. They've proven that they've had the note. However, what they didn't prove was that they had the note when they brought the case, which is what you need to have standing. So in that case, the court both found that the plaintiff didn't have standing at the time it brought the case, but that it had standing, it gained standing during the course of the litigation, so it was a party to the mortgage. So in that case, the court did actually award fees to the defendant. Again, it's kind of an extraordinary set of circumstances, but I think the upshot of it is that, if you're defending these cases during the course of the litigation, it's important to focus on the when plaintiff got the note and mortgage. If you can do that in discovery and you can show, again, these are oftentimes blankly endorsed documents. So if you could get out in discovery, well, they didn't actually have possession of it until they'd actually filed the case. It may be enough to let the defendant sort of have their case or have their cake and eat it too. You're probably going to face another foreclosure after dismissal, but it could be a way to recover fees. So keep that in mind. Again, another one that was suggested, brought this up in the HFC case, attorney's fees as sanctions under 57105 when a court finds a party asserted a position that was baseless or meritless. At the end of the day, the court can award fees as sanctions. So it's sort of a high standard to meet to get sanctions. There's an exception to the rule where if the losing party asserted a position in good faith, argues for an extension, modification, or reversal of existing law, that they can escape fees. There's also the statute requires if a party seeks sanctions that it requires that there's a 21-day safe harbor period. In other words, if you're seeking sanctions, you have to serve your motion on the party that you're seeking sanctions against, give them 21 days to fix whatever they did. And if they don't fix it in 21 days, you can then serve the motion for sanctions, but you do have to give them that 21-day safe harbor period. Again, going back to that HFC case, this can be done on the court's initiative, which doesn't require that safe harbor provision or safe harbor period. So the reason that this might be an issue in foreclosure cases is, like I talked about at the beginning, in these cases, the plaintiffs must certify at the beginning of the case that they have possession of the promissory note. They also require to verify, and this is under penalty of perjury if you read the rule, the civil procedure rule, that all the facts alleged in their complaint are true. So if the plaintiff does all that and then later is proven not to have standing, I think it might be an issue for sanctions because, again, they've certified and verified under penalty of perjury that they do have standing. So, if that ends up not to be true, that could be sanctionable. Just as a very, very quick caveat, I think, this sort of sanctions litigation under 57105(1), I don't think it was really designed to be used as a strategic device to get attorney's fees. But I think one of the upshots of what's going to happen if the Supreme Court rules against Glass is that you may see more of these sort of sanctions motions coming from defendants, which I don't think is a good thing. It may sort of erode civility in the court process, but that may be an upshot of what happens if it's the only way to recover fees. So that's another theory. Again, I'm going to run through this slide real quick because I have never actually litigated this issue, but so I'm not super familiar with it. This was one of the theories proposed in one of the lower court cases, but Florida does have an offer of judgment statute that could result in fees. Basically, if a party, and this is used a lot, I think, in insurance litigation cases. There's actually a whole lot of. It was designed to sort of ameliorate litigation or to sort of lessen litigation, but the issue has been litigated so much it's actually the opposite has been true. But it's basically if you're a party and you make an offer for settlement to an opposing party, the opposing party doesn't settle the case, and they obtain a judgment that is at least 25% less than the original offer or judgment of liability, then the offering party can then recover fees. So I think I'm saying this right. If you're being sued, you say, I'll sell, you make a written offer, I'll settle the case for $100. They say, no way, we're not going to take that. They then prevail in the case and they get awarded $50. That's at least 25% less than your original offer. So the offering party can recover fees, which would be offset by the damages. Fees, they start from the time that you make the offer. So if you're going to use this, make your offers early. There's a good faith requirement, but some cases allow nominal offers to meet that good faith requirement. The cases I read didn't say anything. There was no offers that were less than $100. So I guess that's sort of maybe a baseline nominal offer, just from the cases I read. And that might be another way to recover fees. Finally, if you face one of these cases, you may be able to raise a counterclaim under a different statute. The one I cite here is an example. There's a lot of statutes that can provide counterclaims. I cited the Florida Consumer Practices Act, or Consumer Collection Practices Act 559729. That prohibits any person from threatening to enforce a right which that person knows does not exist. Again, it's a pretty high standard. It's knows, not knows or should have known. It's actual knowledge standard. Why I like this statute is it applies to any person, not just any debt collector. The federal sort of equivalent to this is the FDCPA, which applies to debt collectors, so it's more narrow. This is broad. It applies to any person, which has been interpreted to include mortgage servicers. If you bring a counterclaim under this statute and you prevail, there's attorney's fees that are available. However, as this sort of cautionary tale, there's a federal case out there that says that litigation of privilege will bar recovery under this statute. Litigation privilege, meaning any acts that are taken in the course of the lawsuit. So filing a complaint, asserting standing, may not be a violation of this statute or it might be a violation, but it might be protected by litigation privilege because it's something that's done during the course of the lawsuit. And also a bona fide error defense is available, which might limit recovery. Some other statutes, truth in lending, FDCPA, if it is a default servicer acting as a debt collector, Florida Unfair and Deceptive Trade Practices Act, RESPA, HOPA, there's a lot of them. Okay, so this is a pretty awkward segue because I only have about 3 minutes left, but I did want to spend too much time on that, but I'll try to get through this in 3 minutes if I can. The other case that's now in front of the Supreme Court is a case, credit card case called Bushnell versus Portfolio Recovery Assets. In that case, the creditor, which is a debt collector, debt buyer, I believe a debt buyer, brought an action based on account stated cause of action. An account stated cause of action, it's sort of, I run through it in this slide, but I'm gonna have to skip over a lot of this. Usually, if you've done this, you'll see these account stated claims. What they'll do is they won't attach a copy of the credit card agreement to the complaint. Instead, they'll attach billing statements to the complaint. They'll say, we had a history of transactions here. We rendered these billing statements on the credit card user. They didn't object to the balance that we said was owed. Therefore, we've proven that, that under this account stated theory, that, they accepted our renditions of their account statements to them, and that these are by not objecting to them, these are considered to be true. And this is frequently bought now by credit card collectors because I think of evidentiary issues of proving up credit card contracts. In the Bushnell case, again, a debt collector sued a defendant. Account stated, not a breach of contract claim. Defendant prevailed. Plaintiff voluntarily dismissed under that Thurnberger case. The defendant's the prevailing party. Defendant introduced the credit card agreement, which I think they had gotten to discovery and moved for fees. Of course, the credit card agreement provided for fees to the lender under 57105. Also, defendant gets fees. The court denied the motion for fees, and the reason that the underlying action was not an action to enforce the contract. It was this account stated cause of action. So the trial court certified the question of great public importance is an account stated claim and an action to enforce a contract. Second DCA on appeal said we're going to rephrase that and say more in line with the statute is a credit card is an account stated claim an action with respect to the contract. So I underlined the two provisions here so you can sort of see the contrast between them. And ultimately the second DCA ruled in favor of the defendant and said yes, a account stated claim is an action with respect to a contract. They used a test called the inextricably intertwined test that they got from a Supreme Court case. Props to the second DCA for its alliteration. And they said that the absent the existence of a credit card agreement, there would have been no accounts statements that would even have been generated. Therefore, they were inextricably intertwined, and therefore the action was with respect to the lawsuit. Bushnell has appealed. Portfolio has appealed that to the Supreme Court. And raised some arguments that conflicts with earlier precedents, and the Supreme Court has not yet determined whether it will accept jurisdiction. I don't know whether it will or not. I don't know how long that process is going to take, but definitely another one to keep your eye on if you do debt collection defense. So I think I'm right at 1 o'clock right now. So that's the end for now. I'm happy to stay and take any questions if anybody wants to stay past 1, but if not, I hope this was informative, and please remember these cases, keep an eye on these cases.
Thanks, Matt. Can you hear me okay?
I can, yes.
Okay. We do have a question. Is a ruling on an order to show cause dispositive of standing, given that the requirement that the court must find standing before issuing the show cause order?
I'm going to have to punt on that one. I guess it would be hard for me to say without actually looking at the order itself. Wait, can you read the question one more time?
Sure. Is a ruling on an order to show cause dispositive of standing, given that the requirement that the court must find standing before issuing the show cause order?
Oh, okay. Yeah. Again, is it dispositive? So an order denying a motion to show cause, would it be dispositive that the plaintiff doesn't have standing?
So I think, if the threshold question to be able to issue an order to show cause is the court has standing to be able to do that, doesn't that in and of itself, doesn't the fact that the court issued an order to show cause mean that there was standing? Otherwise, the court couldn't have even issued an order to show cause.
Yeah, I guess in that case, that would probably be true. Based on my own experience, I don't know that when they issue these, if they're not just sort of, basing the courts are not sort of issuing these based on, allegations that are made in a complaint or in a motion, as opposed to sort of findings of fact, that they've reviewed. But yeah, I think that might entail standing if a court issues an order to show cause. I don't know if I answered the question, but
I think so.
Yeah.
And those are all the questions that we have right now. We did at the very beginning get a question about whether they could get copies of your slides. And we will be emailing out the CLE information, which is now on your screen, as well as copies of Matt's presentation. And if you have any feedback for us, we'd be happy to have it. Please consider joining the public interest law section if you're not already a member. And also, please consider taking a pro bono case if you're able from Legal Services of North Florida or from your local legal aid office. Thank you all for joining us today.
Thank you, everybody.
Thanks, Matt.